Eric Plinske, who is the Director of Corporate Affairs for GRMC. Good morning, Eric. How are you?
Good morning, Patty. Nice talking to you again.
Yeah, it is. Well, you know, I'm glad that we're sort of playing this one out on the radio.
Wish it was under different circumstances.
Sure, but it's also interesting that it's also being played out in the media. Not that I'm complaining about it, but I think some things get lost in the translation. Wouldn't you agree?
We agree, and I find, Takecare claiming in their letter that GRMC is a bully and Takecare is the victim. Now, that's a good joke to start off the day. Okay.
Talk to me about whether or not they're saying that you are possibly billing these patients outside of the 90-day requirement under this public law that they're citing.
I can quote it for the benefit of Eric and our audience. And this is from the joint letter in today's newspapers, Eric. The Healthcare Prompt Payment Act of 2000 requires that GRMC submit accurate claims within 90 days from the date that the healthcare services were provided. Under most circumstances, claims not submitted within 90 days from the date of services cannot be collected from either a patient or his/her insurer. Consequently, GRMC's threat to send stale bills to Takecare's members may be in violation of law depending on when services were provided. Takecare going the extra step, asking their members who received a bill from your hospital, Eric, to call them, that they would explain their rights and responsibilities, and, quote, members may also wish to consult with legal counsel regarding their rights against GRMC for trying to collect on untimely claims that may be barred by Guam law.
Yes, glad you read that off. First of all, the Prompt Payment Act of 2000, first of all, they wrongly interpret what that act is. We have our legal counsel have reviewed that, and we stand firm. We have our interpretation. They have theirs. The Prompt Payment Act of 2000 is an act that regulates the relationship between a contracted health plan and a provider such as a hospital. So in lack of a contract, the Prompt Payment Act of 2000 does not apply, and we have letters from Joe Husline himself stating that to GRMC directly, that the Prompt Payment Act of 2000 has no applicability in the relationship between GRMC and Takecare. However, he twisted it and tried to say somehow that the Prompt Payment Act applies between the patient and the provider when there is no contract. It is completely false. So that's our view and our opinion. What the reason for the Prompt Payment Act is that really GMH was not getting paid promptly by payers, and so they set up a relationship, an act that would regulate that relationship as well as other providers, so that when you have a contract, the health plan must receive a clean claim from the provider within 90 days, and then the health plan has 30 days to reply back to the provider if they find any ambiguity with the claim and let them know what it is. And then the provider must respond with 60 days, and then ultimately the health plan must pay within 45 days of a clean claim, or, and this is the clause you were just reading, if the provider did not submit the claim within 90 days to the contracted health plan, then the health plan nor their insured member will be responsible. That's correct. With no contract, completely null and void, and Takecare is the one who didn't want the contract with us to make that act valid for them.
Yeah, and so they're saying that because you don't have an agreement with Takecare, then you're billing for services to Takecare members that don't, and you don't have. There's no contractual right to bill them. So it's impossible for them to owe you any money.
We don't have contracts with their members. The statute of limitations is what applies in this case. So the Prompt Payment Act is only between contracted health plans and providers such as a hospital, not with patients. The part they're reading is a byproduct of them being a member, the patient being a member of a contracted health plan with a provider, which Takecare has no contract with GRMC. They just wrongly interpret the law.
Well, and it sounds like that they admitted what your interpretation of the law was to you in sort of internal communication.
And I got the quotes from Joe himself.
And they're saying something different in the newspaper today.
Well, they're twisting and trying to say that this law applies between patients. Here's how crazy that is. Let's say that their opinion was right. that would mean that an uninsured person that has no job would have the provider would bill them in 90 days, and that would mean that the patient, we don't give claims to patients, we give statements, right? Because they don't know how to read claims. Right. That's what the Prompt Payment Act talks about, claims. They would have to know how to read an ICD-10 diagnosis code. They'd have to know what common procedural terminology codes are for treatments. They would have to know what modifiers are. They don't know this stuff, and then they would have to reply back to the provider with any concerns about the claim within 30 days. And then ultimately the patient then, if they had to follow this law, would have to pay the provider within 40 days the entire bill or face penalties and interest rates of such as 12%. No government would put these folks, like uninsured or a patient that doesn't have a contracted plan, in that kind of a financial predicament.
Now, how far is this going to go? Because this is, the first letter, their response, only 2 advertisements in the newspaper. Your response, your rebuttal is now only to us on the radio station. Is there going to be a coming together, for the sake of your patients and their subscribers? Well,
the only victims here are their members, really, that had to come to us. They came here for emergency care. The overwhelming majority of the time, many times, had to go to inpatient status because of the severity of the care. So for Takecare to claim they're the victim here, their members, and then the audacity for Takecare to really say that, I think their quote was, Takecare's customers clearly see no value in having access to GRMC. That's in their letter today. Yeah. If that's true, really, then why do their members keep coming to GRMC when their life is on the line or when they need emergency care? Over 1,200 visits. I don't know how that adds up. But, and then they talk about how our rates are so much more than GMH. Well, GMH themselves admits that their rates need to be significantly increased to keep up with the actual costs that they're incurring. And then we're a brand new hospital. We have private rooms, so they were talking about room rates. We have private rooms. GMH has semi-private rooms. So there's obviously going to be a price difference there.
Well, there clearly is a difference.
If their GMH rates are so great for them, well, then why doesn't Takecare pay the $9 million that they owe GMH? That obviously they got their own issues over there, and I see the demand letter must have went out, the second one, for them to pay that. So
yeah, we certainly appreciate the difference in the level of services between the two facilities. And have we established the reason why Takecare members will go to GRMC for emergencies? Is it because of proximity of a particular incident, or is it all by choice?
It's a combination of both, Patty. I mean, sometimes, when you're in an ambulance, like we talked about, and your life is on the line, the ambulance is going to go to the closest hospital. They actually usually are under any circumstance, to protect the life or the health of the patient. But even we have many patients that are their members that are driving here for our emergency care. So they voluntarily came here. You got to understand, people are asking, I see some comments on social media saying, well, why does GMA or GRMC keep taking these Takecare patients? Folks have to understand, we are following federal law. We can't turn away patients. We aren't going to turn away patients coming to our emergency room. We are going to care for them and save their life, and that's federal law. EMTALA. No, we don't turn away people, but the unfortunate thing is now the patient is faced with the bill, or ultimately, we've been holding those bills because Takecare policy for out-of-network status is that patients supposed to pay the whole thing, and then if they can get the bill paid, they can qualify for some kind of a out-of-network reimbursement at eligible charges.
Can I just go back real quickly to this point about going to the hospital in an emergency? However an emergency is defined, either by the patient who's suffering some kind of ailment and feels the need to drive straight over to GRMC by choice. It's hard to tell people when they feel real bad what is an emergency and what is an emergency. But nonetheless, having said that, at that point that you take them in, despite the fact that they are not in the provider network, is it not your policy as well to stabilize that patient and then send them off to a facility? And if that's so, why would they be admitted?
Well, Patty, you're right. The stabilization is the federal law, and that's what we do. But if we do in times, and if the member especially is asking to be transferred, it's patient-driven. So if a member or a patient is here and they're a Takecare member and they were in our emergency room, but they say they want to stay here, we are not going to force them to leave. No, that's their choice. We do have to advise them that they're out of network. We give them a notice, but we do try when they ask to be transferred. But you got to realize that GMH is strapped too. They're working hard. They got beds are full. We've tried many times, and they can't take the patient because they themselves have no bed for the patient. So then I guess Takecare expects us to coordinate the off-island transfer. That involves passport updates, oxygen uptake for the airline. The patient needs 9 seats. Did you know if you're in a stretcher on a plane, you usually have to do a 9 airline seat purchase because they can't sell those tickets around you. We can't get involved. The health plan should be doing all of this, and they put the responsibility on their member to call them within 48 hours if they're in the emergency room, or if you get admitted, you have 2 business days as a member to notify them of your admission, or you're not even qualified to get reimbursed at all after you pay the entire bill. What inpatient that had a heart attack is going to be trying to call Takecare in 2 business days while they're still in the hospital to let them know they're in the hospital?
Caller asking, are the rates that GRMC proposed to Takecare similar to what was proposed to the other insurance companies?
Well, yeah, we've offered. That's what's so crazy. They're saying that they have determined that we are just so outrageously priced. We've talked about this before. Negotiations allows them to get negotiated rates for themselves and their members, like the other 3 health plans have done. If their argument was correct that we're too pricey, then why is every other plan contracted with us saying that we were reasonable enough to do it? And they were offered similar rates, so that goes out the window.
Where are we going from here? Now it feels like if I was a customer at Takecare and I was expecting a bill from you, I'd be very uncomfortable in just listening to the back and forth today.
It sounds like they're encouraging their members to roll the dice and to don't take GRMC seriously about a bill, and even to go hire their own attorney. Sounds like a great. What kind of advice is that? They're taking the premiums, they're not paying any of the bills, and then they are encouraging their members to hire an attorney or do something of that sort to challenge us, or just don't pay the bill because Takecare believes in their own interpretation of the Prompt Payment Act that they don't have to pay it.
But in effect, you have also, on your part, Eric, have recommended.
Call the industry. I mean, I came from the insurance industry. We know this bill. Call Simon Sanchez, former Senator Simon Sanchez, the author of this bill that became law. I've talked to him myself. I called him just to make sure I got this right. He agreed.
Okay.
This is not anything to do with the patient. It's about the health plan, the contracted health management maintenance organization, HMO and health plan. That's what the law is about.
Okay. So what's the answer here? You're going to continue to bill Takecare members, and how far into this are you? I asked you this the other day. Now that you've gotten this response to Takecare, it sounds like the blood pressure went up just a hair.
Well, the victims, like we said, are the Takecare members that are, and we feel for them, and we are, addressing their calls. And Takecare has got a lot of them going over there. But the thing is that we have to be compensated for the care we provided, and we have been trying, even though Takecare is saying that we aren't authorized legally to bill them directly. It's supposed to. They're telling us you should be sending it all to our patients. That's the way it's supposed to be. But we don't even like that idea because we feel it's unfair. That's why we've continued to still try to send it to Takecare to work out a settlement, because we said if we can work a settlement, we won't bill your patients, and we can move on. But it's a 2-part deal here. It's not a 1-part deal. We need a contract for moving forward so we don't have this continue, and we need a settlement for the old claims so we don't have to burden their members with the bills.
So Eric, putting maybe through a lens of a patient that maybe is seeing all of this and just maybe resigning to the fact that they are going to have to pay out of pocket. Let me just ask you, is GRMC open to payment plan options for your patients to make good on whatever bill they may end up on their laps?
Well, I can't really get into what we're going to do. I mean, the bills have to go out, and then we have to seek compensation. We will talk to to the patients as we have been. we understand their predicament. We are just trying to, ask them, like you said, they are not in this alone. The federal market's open bid is right now. Call federal OPM if you're a federal government employee or a retiree. Call them up, and they will step in for you. Call Gov Guam, DOA. Christine Beleto is the chair of the insurance health plan and negotiating team that'll be doing their negotiations next month, and let them know, and they'll have to call Takecare or deal with your employer, HR director, GM, whoever made the decision to choose Takecare with an out-of-network GRMC. Let them know the financial predicament you're in, and I think they'll be calling Takecare on your behalf. And Takecare can't ignore those calls because those calls represent hundreds, if not thousands, of people. And if they don't like what they hear, those organizations can take their business elsewhere. And any health plan, I came from health, cannot survive in that kind of an environment.
Well, Eric, thank you so much for the phone call. I think we really appreciate the, obviously a public tit for tat is not comfortable for either party, but like you said, there are hundreds, if not thousands, of people who have these really big questions about what does this public spat mean for them.
Yeah, I think that Takecare right now is finding out it really difficult explaining to their members who are going to them where they denied emergency coverage and saying that this is real common, that they're saying that the person went to the emergency room, Patty, you mentioned this, that Takecare decided that the emergency room visit was non-emergent, meaning you went and used an emergency room and it was not really an emergency in their opinion, and so they deny it based on what's called non-emergency use of the emergency room. That's a common denial, and they're dealing with this at their office. They have a hotline they've established. We're not even in their network, and we're the option number one on their dial is for any GRMC billing problem or complaint, push 1. For all other matters that Takecare, press 2. That should tell you how they claim that their members don't really care that we're not in their network. I don't think they'd have to set up a hotline for very angry Takecare members related to GRMC if their members were not concerned about us not being in the network.
Appreciate it. I think we've pretty much said as much as we can say for the moment.
Sorry, folks, but we apologize to the Takecare patients affected by this. We really feel bad.
Would there be? Isn't it out of the turn to discuss the possibility that there could be some legal action taken against Takecare at this point?
Well, we've been always open. Our goal here is to have Takecare reconsider them leaving about the negotiating table on a settlement and ignoring, I guess, the proposal to have a contract and come back and talk to us. The door is open.
Okay, at what point will that door shut and you won't?
Well, I'm not sure the door ever shuts. It's just that their members have to deal with the financial consequences of that delay every single day we go forward. So, that's where the ball's in Takecare's court. The door's open. We're here. Can you get anyone from Takecare on the line live? I doubt it. You'll have to wait for, another statement in 3 days or so in writing. But, talk to them, find out. We'd be interested to hear what's their position on that.
All right. We'll make sure we pass that word on to you because it seems to be being played out here on the radio, which we have no problem doing. Eric, as usual, thank you so much for your time.
Thanks, everyone. Talk to you later.
All right. Have a good day. Have a good weekend.